But just for the record, as you'll see, we are recording this meeting, and we will have it. There is a Zoom link. Secretary Green is joining us virtually, and Mr. Harvey may be joining us virtually as well. We will go ahead and get started at this time.
All right. Well, hello everyone. It's great to see everyone in person again, even though I had come back, I guess, during virtual, but it sounds like you've been pretty virtual since I left. So it's nice to see everyone again. As it goes, I'm glad I got here when I did. Court ran long. It's always the cases you don't think are going on. They did. So first thing we wanted to do is recognize two of the members who I had the good fortune of working with when I was here before, that we are sadly going to be losing. First of all, as to Judge Salmon, since September 26, 2014, he has served as the appellate court representative for the Maryland State Commission on Criminal Sentencing Policy. Judge Lewis has served as the district court representative. As of September 25th, 2022, both will have completed 2 4-year terms as members of the Sentencing Commission. And I've always said, I had done a lot of commissions, part of a lot. This is a very active, substantive committee. It's not just put your name on the committee. And so 8 years is an incredible contribution to the Sentencing Commission. Certainly, I personally, and I know everyone is disappointed that they are nearing the conclusion. But as I said, very grateful for the 8 years that they have given. I know personally, having been involved, they've always very thoughtful input. I think we had great debates many times on issues. And one of the things I will say is, even when there was disagreement, I always came away learning something or a different position, which is really, I think, the beauty of this commission. So personally, I'm very grateful. I know the committee is very grateful. So on behalf of the Sentencing Commission and staff, it's my honor to present these plaques to both Judge Salmon as Judge Lewis in grateful appreciation for your dedicated service to the citizens of Maryland as members of the Maryland State Commission on Criminal Sentencing Policy. I thank you again, both of you. You will definitely be missed by the committee.
Thank you so very much.
Absolutely.
I'm going to take a point of personal privilege. I would like to just commend both of you for the work that you've done on this commission, and I want to express my personal sadness that you're going to be here because even though we're judicial colleagues, we're in different places, and we hardly ever get to see each other. And throughout the time that I've spent on this commission, I feel like I've just really enjoyed working with both of you. And we've worked through some really complex issues and hot topic issues. And I think in particular, Judge Lewis was what you. I think you've helped me see things in a certain light through your unique moral and legal compass, which is always pointing in the right direction, I feel. And you were my judge when I was appointed, who helped guide me through that process. And I'm going to miss seeing you. And also Judge Salmon, who was, when I was an appellate lawyer for 16 years, Judge Salmon was always one of my judges on the Court of Special Appeals. And I feel like you've been a stalwart here on so many issues, and I really appreciate both of you so much, and I miss you.
Anything?
Should we just switch on the next time?
Well, we've got a shirt if you take the plaque by Starbucks and get like a grande out of it. So you can try to see it. But again, thank you both very much. I hate that you're you'll be leaving, and I echo what Judge Abrams said. I remembered some of the real discussions, even on
Right.
juvenile scoring and so forth, that I think we all came to a better product because I think we were really all wanting to do the right thing. So again, thank you both very much. With that, Ed, you might get called back again, apparently. It happens. So in your packet, you would receive approval of minutes from July 12, 2022 meeting. So if you've not had a chance to review those, if there is a motion to accept the minutes. All right, is there a second? All right, every second. Is there any discussion about the minutes? Seeing none, all those in favor, say aye.
Aye.
Anyone opposed? Anyone opposed, the minutes will be adopted. So with that, we have the guidelines subcommittee report, a lot of active discussion, I understand on that, Judge Avery.
Yeah, okay, thank you very much. The guidelines subcommittee met on August 30th at 12 noon, and we reviewed 4 items, only 3 of which are on our agenda tonight as action items. So at this time, I think it would be best if I let David present on the first one.
Absolutely. Thank you. Appreciate that, Jeb. Just before I do so, I just want to recognize that Mr. Harvey has joined us. Did admit him? Hopefully, yes, he is there. And also just wanted to take a second to recognize that Warren Davis is here with us tonight as the representative for the Attorney General Frosh. Casey Murphy, I should say, who is our usual, we probably should take a minute to just recognize that. Casey Murphy, who has been a longtime representative of the Attorney General, was recently appointed as a district court judge for Baltimore County. So I think she will be sworn in by the end of this month. She was originally planning to attend this evening. However, she had a family-related issue that she needed to address. So
Used to be my chief deputy while I was state's attorney.
oh, really?
Yeah, I knew her from the Attorney General's office.
I should just take a minute to recognize Casey has just been a tremendous asset for the Sentencing Commission during her time. She served in that role for a little over 4 years, and she had sometimes helped us behind the scenes with various legal issues, et cetera. So we always appreciated having her, and happy to have Warren with us here this evening as well.
Thank you.
Okay, so getting on to the guidelines subcommittee, I will present the first agenda item, which is the review of the response to the Maryland Alliance for Justice Reform request. As you may recall, those of you that were with us, a retired circuit court judge, Judge Philip Karoom, representing the Maryland Alliance for Justice Reform, presented testimony to this commission, both at our 2021 and 2020 public comments hearing. And a copy of the testimony from the 2021 hearing was redistributed to you all with the materials for tonight. The December 2020 testimony is almost exactly the same, so we didn't redistribute that. The testimony that Judge Karoom presented on behalf of the Maryland Alliance for Justice Reform presented 3 recommendations for the Sentencing Commission to address. And those recommendations were the following: that the Sentencing Commission should add new data fields to the sentencing guidelines worksheet to collect information regarding charges that were reduced and or dismissed, and include data fields to allow the prosecutor's office to provide an explanation for reduced or dismissed charges. The second was the commission should add a new data field to identify whether participation in a corrections option program or other alternative to incarceration was a condition of a plea agreement. And then the final major recommendation was the Sentencing Commission should create a new additional database to collect data regarding probation violations. The Sentencing Commission did not take action on the Maryland Alliance for Justice Reform's recommendations immediately in 2020 or 2021. However, it was noted that the recommendations should be reviewed and that the commission should provide a response to the Maryland Alliance for Justice Reform, so they don't necessarily feel the need to testify again with the same specific recommendations. So the subcommittee at its August 30th meeting, which was completed via video conference, reviewed the recommendations again and a draft response was prepared by the staff. The subcommittee offered feedback on that response, and a revised draft response was created and distributed to you all for this evening. So the response, first and foremost, expresses appreciation for the input of the Maryland Alliance for Justice Reform, but also notes that the Sentencing Commission does not expect to take action on their specific recommendations. The draft response further notes that while each recommendation warrants consideration for its ability to help identify potential causes for disparate incarceration rates, the Sentencing Commission believes the individual recommendations are either more appropriately addressed by another state agency or work group, or that the recommendations exceed the scope and resources of the Sentencing Commission. So with respect to the first recommendation, the Maryland General Assembly passed during this last session Senate Bill 763. And that created, among other things, it created a task force to study transparency standards for states' attorneys. So the response notes that that this task force may be the more appropriate entity, probably more likely to address the recommendations regarding to collect information about charges. The response also notes that the sentencing guidelines are calculated based strictly on convictions. The guidelines are not calculated based on charges that may have been reduced and/or dismissed, and therefore the guidelines worksheet may not be an appropriate mechanism to collect data on charges that do not result in a conviction. With respect to the second recommendation, the draft response noted that MAGS, the Maryland Automated Guidelines System, and the corresponding guidelines worksheet already collects information about participation in alternatives to incarceration. Additionally, the guidelines worksheet identifies if a case was adjudicated pursuant to a plea agreement. And with respect to the final recommendation, the draft response notes that the Sentencing Commission believes the request is duplicative, as the data that was being suggested to collected, specifically data about probation violations, is already being collected by the Maryland Administrative Office of the Courts. And the Sentencing Commission does not have sufficient resources to create a database and collect, maintain, analyze, and report additional data on probation violations. That would something that would require substantial additional funding. The draft response notes that the Sentencing Commission is not statutorily charged with collecting any of the additional data that were recommended by the Maryland Alliance for Justice Reform, and therefore summarizes that the Commission believes those additional requested responsibilities exceed the Commission's role and scope. So in conclusion, the subcommittee recommends that the full Commission adopt the draft response and distribute this response to the Maryland Alliance for Justice Reform in a timely manner. So I will end there and turn it over for any comments or thoughts. But otherwise, we would, entertain a motion to adopt that draft and give staff permission to distribute.
Yeah. Thanks. I just have a question in the draft response to the third request dealing with information concerning violations of probation. One of the reasons given was that the Commission doesn't have the resources to create a database for this information. Now, as I recall from Judge Karoom's testimony in December 2020, what he had proposed was to add some additional questions to the existing sentencing guidelines worksheet, like was the probation revoked, was the revocation a technical violation, etc., like 4 separate questions. Could you just help me or explain to me why that would be unable to be done in the existing database now with existing resources?
Right.
It seems to me that just on its face, it would appear to be just a simple software modification to collect that information.
Right. So the reason is that the guidelines worksheet is not initiated or completed for a probation violation case. So I don't know the numbers of those offhand. I remember looking into this years that we're talking about 20,000, 30,000 violations across the state per year. I think that number is a fair record. So those would be in addition. So we would be creating a new database to collect that specific information about those violations. So that wouldn't be an incident a minor request, I guess I should say. It would be to collect. Now we're asking people to start filling out this new worksheet, if we would call it that, or whatever it is, even if it was a short, brief one, for an additional many thousands of cases beyond what we're currently doing. Those are not guidelines eligible cases, so it would be above and beyond to create a new worksheet to address just probation violations. The commission did look into this issue many years ago. I can't remember the exact time frame, but we decided that we wouldn't do that because the guidelines are not intended to be utilized for probation violation cases, right? I think the impetus behind collecting that data would be if you were trying to establish new guidelines that were applied strictly for probation violations. And because the commission didn't see that as the intent of the sentencing guidelines, there wasn't really that wouldn't require the need to collect the data to be able to get all the information necessary about probation violations. So it's not a small request to be able to add in new information to collect that. The other thing was that the Administrative Office of the Courts is collecting all the information that is being requested. I've seen the reports. It has the very information that Judge Karoum requested in that. So I wasn't even sure why it was asking for an additional reporting system regarding probation violations.
Now, correct me if I'm wrong, though, Dr. Saleh, but one of the issues that we'll be discussing later on tonight was the inability to get information on technical violations. That all the sources that the commission staff went to tell you whether it's a violation, but they couldn't, hone it down to whether it was a technical violation or not, and thus can't really, make any determinations if technical, the extent to which technical guidelines or violations are being overridden by the judge, et cetera. It seems to me that if this information was collected at the time of sentencing, that pursuant to MAGS, that would be the best source for collecting that data. So I would just throw that out there.
I would make a clear distinction, right? For that component, we're talking about in the prior record. So we're talking about someone, for the issue we're going to discuss later, we're talking about someone who's being sentenced now. Did they have a prior violation in their prior criminal history? And the people that are completing the guidelines, the prosecutors and parole and probation agents, the question was like, how easy is it for them to determine whether this prior violation was a technical or non-technical violation?
Yeah.
I think what Judge Karoum was suggesting was starting a new database for current probation violations, right? And tracking that information like he's requested moving forward. So I think those are two separate issues.
Yeah. Again, they are, but if one of the purposes of the commission is to look at sentences and sentencing, and that's in enabling legislation for the Sentencing Commission, as you well know, doesn't talk to whether or not the commission is charged with looking at civil cases versus which may be violations of probation versus criminal cases. It says sentencing should be fair and proportional, and sentencing policies should reduce unwarranted disparity, et cetera, et cetera. Violation of probation sentence is the sentence. And if there is this large percentage of people who are incarcerated as a result of violations of probation, then it seems to me that it would be impossible for the commission to have all the information to make informed choices with this large piece being missing. That's my only comment on this issue.
I don't understand what you mean by choices. Like, what choices are we making about probation?
Well, no, and the larger issues of addressing various factors that are set forth in Criminal Procedure 6202, which have to do with the purpose of the Sentencing Guidelines Commission, which is to look at at such things as to whether sentences are fair or proportional, whether there are reducing unwanted disparities. If you're not looking at one portion of the life of the case, which is the violation of probation that results in people becoming incarcerated, I just don't think that we're getting the full picture to address those issues.
I mean, I'm just going to speak up because obviously we discussed this at length at the guidelines subcommittee. And we all have different viewpoints on it. I'm just going to say that what I have seen over the years is with this commission is that no good deed goes unpunished. So to the extent that our very small and limited staff do very good work, there are a lot of organizations and advocates who want to give this staff more work. And I have come to view part of our job as commissioners to abide our enabling legislation and to keep our purpose very focused on what we're doing. Because the more we pile on more and more responsibility, the less the focus of the sentencing guidelines becomes diffuse. And I think if that happens, to your points about disparity, that ends up having, in my view, a regressive effect. So that if people don't understand, judges in particular, what the sentencing guidelines are and what the purpose of this commission is, and they view this commission as a watchdog or something, like that, then we get into serious compliance problems, which ultimately will lead us down the wrong path. I believe that we really need to abide the last sentence of the second to last paragraph, which is that these additional responsibilities exceed the commission's role and scope. I believe that the request that was made does exceed the role and scope of the commission right now. And I think that if any of these advocacy groups want this commission to take on new responsibilities with regard to monitoring the disparities or monitoring anything about violations of probation or post-conviction or something like that, the legislature is going to have to authorize that. The legislature needs to tell this commission that they want the commission to do that and fund that mandate. I don't think that we can say yes to everything without damaging our underlying purpose.
Anybody else want to add anything?
Can I just say that the confusing part about what he said, and it may be the way I look at it, but I only sentenced the defendant once. I give the defendant a sentence. It may be suspended contingent on conditions. When those conditions cease to exist, judges are sort of the opinion, maybe so should the suspension of the sentence. So the answer is the original sentence is the original sentence. It's not like I'm going back in and saying, and now I'm giving you more time, okay? Because I started out from the very beginning giving the sentence I intended to give. There may have been an incentive to encourage rehabilitation, educational opportunities, yada, yada, yada. But the sentence has always been reported. And this is not an enhancement. The sentence was given. And the judge needs to always look at it that way. From the day you sentence the defendant, you've made that big decision. And that's why the defendant has taken an appeal or not taken an appeal, done whatever they've done. But that's the advice they get on the sentence that's actually given. But what happens on a violation of probation is things have happened. And that's why some judges took issue with the JRA, because not at all times do we take action with something. There's an argument point about if there's a stay away order and somebody violates a stay away order. How strongly do you feel about that? That's considered a non-technical violation. That can be, a lot of people can argue that point, right? So I'm just saying, but please remember the sentence hasn't changed. The original sentence that was imposed is the one that's been imposed. It's just what we're talking about is executed time. So it's, I don't think that's a distinction without a difference. I think that's an important. The sentence has always been recorded as it was.
Yeah, I would just respond that I understand what you're saying, and a lot, some judges, I think, look at it that way, but if you're, my experience is that many judges will give a suspended sentence to give a first offender a break, but also want to retain the full scope of the potential sentence for any violation of probation. So, I mean, I definitely agree with what you're saying, but just have not experienced that across the board.
That's what you should be considering, because yes, I've had colleagues that say, okay, sure, I'll give you the 10 years on that second degree assault. I'll suspend it all and da-da-da, but you gotta understand that's, depending upon who the client is, that's what they're looking at. And it would be inappropriate to not properly so advise, right? Because that's the full frame. But the answer is the benefit today might not be the total benefit. It's a thought.
Yeah, I certainly, understand, and certainly respect the benefit of your view on this, having served with honor and distinction on the bench for so many years. I would just counter that when someone goes to jail as a result of violation of probation, that is a sentence too. The courts regard that as a sentence. The Court of Appeals, and I believe it was Pitts versus State, says that it is a new sentencing event in which you have the rights to a modification of sentence. Someone is going to jail who was not in jail before. So although it's not the original sentencing event, it is also a sentencing event. And
Not a sentence.
well, and as such, I just think that it's it would be important for, and maybe it would need additional resources to do so. But I just wanted to express the opinion that, until we get a handle on policies and trends and data concerning violations of probations, we're not getting the full picture of what's happening in the Maryland courts, so that we can answer questions that the General Assembly created this commission, to provide answers. I'll leave it at that.
All right, well, I just add a couple things. So my understanding, first of all, is there's kind of two components. One is the data, which sounds like AOC actually has. Is that right, David? It has the data. So then the next step would be our reasoning, at least my take on it is our guidelines are reflective of what people are doing. So if we're asking someone to do a guideline for a violation of probation, we have no guidelines for that. We don't have any guidance for the court. And we wouldn't have it until at some point down the road, we got enough sentences to create guidelines. So I guess that's the way I saw this is the data collection point seems to be happening. The issue is who's doing something with the data. And that would, in my opinion, be in a whole nother drain on the resources because I don't know how we would marshal that data or make it actionable in some way. Because I agree, I think there's a sentencing there, but we don't really have any guidance to judges. Like, well, if it's a first violation, this is what judges generally do. I'm not even sure how workable that could possibly be. For exactly what Judge Lewis was saying, different violations are different. But I mean, that's the way I see it. There's a collection portion, which is happening. And there's a what do you do with the data collection portion, which I think is where this would lead. It's like mission creep,
Right.
you want it to be in the guidelines. I think people do because they do a fabulous job, but I think that's definitely a whole nother area that I think there would have to be a real discussion up front on funding and resources. That was my take on it, but not that it may not be a good thing to do at some point down the road, but I think that's a really.
This commission doesn't have to be the one that does it. There are executive offices that can, and I've pointed the finger to the executive branch on numerous occasions because they have the ability to collect and analyze data. The advocacy groups can request data from the judiciary, which I know has been a problem, but as we move forward with MDEC and digitizing our files more efficiently, that data will be accessible. And I welcome that the production of that data, but this commission doesn't have to be the body that collects and analyzes the data, and unless and until the legislature tells us that we have to. And I think that, if we try to take that on, then we are going to be undermining our current mission.
All right, anyone else, or is there a motion to accept the letter as written? Any motion? Okay, we have a motion, a second. Second, okay, any further discussion? Seeing none, all in favor of approving the letter as written, say aye.
Aye.
Anyone opposed? I'm sorry, I didn't mean to forget you again. Anyone opposed?
Aye.
I think we're still an aye. So-
Yeah, I think so too.
All right, very well. So that passes.
Okay, the second item on the guideline subcommittee agenda, I'm going to ask Sarah Bowles from our staff to present this issue.
Well, on a related note, I'll refer you to the memo scoring technical violations of parole, probation, or equivalent supervisory status under Part D of the offender score. At the guidelines subcommittee meeting held on April 25th of this year, Mr. Fincy raised the question of whether, following the enactment of the Justice Reinvestment Act in 2016, practitioners calculating the guidelines should treat technical violations of probation, parole, or mandatory supervision the same as non-technical violations when scoring Part D of the offender score. Part D of the offender score requires the person calculating the guidelines to score 1 point if the offender has had a prior violation of probation, parole, or equivalent supervisory status. Mr. Fincy noted that scoring an extra point on the offender score could result in a significant increase in the recommended guidelines range and proposed that technical BOPs not be scored 1 point under Part D of the offender score. The guidelines subcommittee agreed that the issue should be reviewed, and this memo presents the findings from their review. The question that was presented to the subcommittee was whether or not the guidelines should account for the technical versus non-technical nature of BOPs. As noted, Part D of the offender score assigns 1 point if the defendant has had a prior violation. Presently, the instructions make no distinction between technical and non-technical violations, as prior to the enactment of the Justice Reinvestment Act, there was no distinction. The Justice Reinvestment Act provided a definition of and placed limits on the amount of incarceration that judges can impose for relatively minor violations, referred to in the law as technical violations. Per Correctional Services Article 6-101, technical violations are defined as those that do not involve an arrest or a summons issued by a commissioner on a statement of charges filed by a law enforcement officer, a violation of a criminal prohibition other than a minor traffic offense, a violation of a no contact or stay away order, or absconding. All other violations would be considered non-technical. The Correctional Services article goes on to provide limits as to the maximum incarceration time that may be imposed for technical violations. A court may not impose more than 15 days of incarceration for a first technical violation, more than 30 days for a second violation, or more than 45 days for a third violation. For a fourth or subsequent violation or a non-technical violation, the court may impose any sentence that could have legally been imposed for the crime of which the person was convicted. There is also a provision in the law providing that a court may exceed these limits if it finds that adhering to these limits would create a risk to public safety, a victim, or a witness. Distinguishing between the technical versus non-technical nature of a violation may be relevant relevant to the guidelines. The intent of the Justice Reinvestment Act was to reduce the incarcerated population. Including technical violations in the scoring of Part D means the defendants with only a technical violation in their past receive 1 point, thereby increasing their guidelines. Whereas excluding technical violations from the scoring of Part D would mean that these same defendants receive 0 points for Part D, thereby lowering their guidelines and reflecting the Justice Reinvestment Act's emphasis on reduced incarceration. If the commission is inclined to distinguish between technical and non-technical violations in the scoring of Part D of the offender score, there is one note of caution. And that is that the technical versus non-technical nature of prior violations may be difficult to determine by the assistant state's attorneys and parole and probation agents who compute the offender score. In preparing the memo, staff reached out to several sources to determine the feasibility of accessing this information. Typically, practitioners initiating the guidelines rely primarily on the defendant's rap sheets when computing the offender score. We spoke with a representative from the Department of Public Safety and Correctional Services, which maintains the rap sheets, and they advised the rap sheet contains arrest information only and no information to distinguish the technical versus non-technical nature of violations. Staff also confirmed that the technical nature of BOPs cannot be determined via Maryland Judiciary's case search. And finally, staff communicated with Mr. Harvey and a representative from the Calvert County State's Attorney's Office, who advised that MDEC, the case management system used by the courts, typically does not contain information to distinguish between technical and non-technical BOPs. So given all this information, staff presented at the August 30th subcommittee meeting 2 possible courses of action. One would be to take no action, meaning that both technical and non-technical violations would be scored under Part D of the offender score. Alternatively, the commission could treat technical BOPs in the same manner as it treats offenses eligible for expungement. Presently, Chapter 7 of the manual provides that adjudications proven by the defendant to have been eligible for expungement are excluded from an offender's criminal history, which is Part C of the offender score. So similarly, the commission could decide to score 0 points under Part D of the offender score if the defendant is able to demonstrate that the only violations included in the prior record are technical in nature. Given the laborious track of tracking down detailed information about offenders' prior violations, it may make sense to shift that burden of demonstrating their technical nature to the defendants who are in the best position to know whether their prior violations were technical or non-technical. These options were discussed at the August 30th subcommittee meeting. At that time, 2 members of the subcommittee voted to take no action, arguing that all violations, even those that are technical in nature, should be reflected in the offender score when calculating the recommended guidelines. And 2 members voted to adopt language that would treat technical violations the same as offenses eligible for expungement, and that they would not be included in Part D of the offender score if the defense could prove that the violations were technical in nature. Due to the split vote, the guidelines subcommittee has no specific recommendation for the commission, but is presenting this information for your consideration. If the commission would like to make any revisions, included in the memo beginning on page 4 is proposed language to address the revisions to Part D of the offender score in both the guidelines manual and COPA. That concludes my introduction. I will turn it over to the commission.
All right.
All right, point of information question. Dr.
Yes.
Slade, do you happen to remember what was in the JRA with respect to the commission when the JRA was passed? Like, I recall something about what the commission's role was to be with respect to the guidelines.
I mean, with respect to the guidelines, the commission was asked to study alternatives to incarceration and corrections options. I remember we did issue a report on alternatives to incarceration as a result of that. But there wasn't any specific statutory requirements with respect to the scoring the guidelines or anything of that nature.
Okay, I couldn't remember, but I do recall that when the JRA was passed, well, first we were at a point where we were looking at the guidelines for any adjustments that needed to be made statistically. We deferred doing it to wait
Correct.
to see the effects of the JRA on the statistics we received, and then subsequently went forward with the more recent
reduction in some of the guidelines related to drug offenses and theft offenses.
Right, because the
Property.
JRA did reduce the penalties for a substantial number of offenses, particularly the drug possession offenses and low-level property offenses. So the commission, as you probably recall, we had just made revisions to the drug matrix. And then Justice Reinvestment came along and kind of like overrode some of those revisions, to be honest, because they decreased possession offenses, the penalties for all of them. So the commission did subsequently recategorize many drug and property offenses, basically decreasing the seriousness categories to reflect the lower statutory maximum penalties. So that was a role that the commission did take. That wasn't something that was outlined in the Justice Reinvestment Act itself, but it was an action the commission did take in response to the statutory revisions that came about because of the Justice Reinvestment Act.
So another point of information I'd like to make that I didn't hear in the report was as this issue came up in the guidelines subcommittee, I did some personal research and located a new form that the district court, well, actually both district and circuit court was created within the last few months that started to be used in district court, where at the very top of the form, when a probation violation is found, there is a box to say whether it was technical or non-technical. Now that form is being used in all district courts, as I understand it now, and in some circuit courts, but not all.
Are you referring to what I emailed? I emailed out the form
No, I actually found that I think we, at the same
same
time.
time.
Yeah.
Yeah, that was a form. So that's, I think when it first came up and you said a form, and I had never seen anything like that.
Right.
So that's what I did. I went to the clerk's office and asked. I was like, and they were actually not even aware of it. They indicated to me they report technical violations. And I think there's somebody else had that information too. They report it differently, but weren't actually using that form. And it sounds like district court, there's a little more uniformity probably, and they were, but
Use it every day.
yeah,
The bottom of
circuit
the-
court,
In the bottom of the form will be a date.
Yeah.
When the form was generated, as well as the month. And that's when it's been mandatory,
5 months.
and it's for both district and circuit, isn't it?
the form does. So the one I had sent
Well,
out
there you
just
go.
was the
Fact,
updated
circuit
form.
courts put a blind eye on it.
It doesn't sound like.
But you see, there's
everybody
a
uses
form, it's generated, and there will be a month and a date when it's supposed to happen.
it. You're not doing this right.
You don't know about it?
Right. So what our research found was pretty quickly, there's not uniformity.
Attached to
There's not
every
uniformity
violation of
from court to
probation
court
filled
in
out at
use
the
of that
hearing.
form.
But I guess that only solves one issue, which would be going forward,
Correct.
having that. But I think what I was told was it's required to be reported, whether it's technical
Correct.
or not.
Correct.
It's just not everybody's using that form. So they're
Right.
reporting it a different way in a lot of the circuit courts.
It's not necessarily getting into MDEC. So that it's not in it. So that information is being collected, but there's not a universally utilized mechanism for it to be found. This issue really is kind of, you can break it down, look at it 2 ways, right? There's a policy issue. You know, should technical violations be scored, differently or counted differently when scoring the prior criminal record? So that's kind of the policy question, I think, is a very valid question for the commission to answer. And then if the answer to that, depending on what the answer to that is, the question is, all right, how can we score that in the guidelines? And so that's why you saw the approach that the staff took was making the recommendation like, okay, if we don't know that there's a universal way for this to be, scored by prosecutors and parole and probation agents who are calculating the guidelines, then we came up with to treat it the way we did sorry, just lost my train of thought. Treating it the same as an expungement. Thank you.
Yeah.
So there is that alternative solution. So
Well,
I think
I
it's kind of a twofold question.
Yeah, I was going to say, so for the benefit of the discussion, obviously it was split.
Correct.
Is it better to start on the policy discussion about whether or not?
I think so, because the second part is.
And then the
yeah.
second part is how do we do it, which is a whole different
Right.
can of worms, right? I mean, I wasn't present for the subcommittee. Obviously, there's differences of opinion. Who wants to present?
Well, I mean, I can at least speak to some of the issues that we discussed in the guideline subcommittee, which number one, it's asking the practitioner who's filling out the guidelines to find out more information that is very difficult to find out, apparently. And again, for me, it's adding another layer of work to creating the guidelines, which just I think I'm against. Because again, the more you pile on and you make it longer and harder to fill out these forms, the more we complicate every single section with all of these nuances, the less likely it is that people are going to fill out the form, fill it out properly. We already have so many errors that are made in this process. But secondly, a technical violation of probation is not the same as an expungement. A technical violation of probation is still a violation of probation. You're still non-compliant with the order of probation that was issued by the judge. You have done something to merit being hauled back into court, which, by the way, requires a lot of administrative functioning and expense. Like, your probation agent has to, first off, file the violation, which in my opinion, there's you've gotten over the initial discretion that I find with a lot of probation agents where they don't even want to file anything. So they file violation of probation. You have to find that there's a violation, and then it's determined whether it's technical, and it is still a violation. So even if you get 45 days for it, you have proved that you were unable to comply with the terms of your probation, which is, from a theoretical standpoint, it's a privilege. It's the price you pay for being out instead of in. And I'm not going against JRA. I think JRA is a good thing. I just think that the value of JRA is provided at the point of the violation of probation, when it's determined that it's technical. The judge cannot bang you with 10 or 20 years because you came up dirty on your drug test. That is the value that you get from JRA. That is how JRA works. But to compound that value by telling practitioners and judges that they can't essentially can't even consider the violation of probation, I think goes against all policy, because you're saying treat it the same as an expungement, but expungement law is, the idea behind expungement is that it is as if you were never convicted. And so the legislative purpose of expungement is to put you, once you've expunged your offense, your conviction, you are now considered to be completely conviction free with regard to the expunged offense. So you are on the same level as a person who was never convicted of that crime. That is the legislative policy. That is the public policy. It's as if you were never convicted. There's no legislative or public policy that says that a technical violation of probation should be considered as if it never existed. So for us to impose that policy, I think is outrageous.
Let me just, can you all hear me? Can you all hear me? This is Bob Harvey, Calvert County State's Attorney.
Yeah, we'll
Let
have
me
you right
just-
after Delegate Moon.
Mr. Harvey, can you just hold off 1 second? Delegate Moonette was starting, and then
Sure.
Okay,
No problem.
thank you.
I was just gonna say, for the legislative perspective here, I was on the Judiciary Committee when we slugged through the Justice Reinvestment Act. I think Senator Sidnor would probably have a similar recollection of this, but the issue of technical violations was something that generated lengthy discussion about the merits of when and how much time someone could do for a technical violation, and this sort of idea of control of the defendant and consequences and the sort of privilege of lenient treatment was all considered. But I'm actually quite surprised to hear that we would want, beyond whatever the punishment was directly for the technical violation, to not be the end of the matter. I think that flies in the face of, I think, what we had anticipated what would happen for a violation of that nature. That was sort of it. And we were, I think, very specifically concerned about there being ongoing, possible, unexpected, negative possible retakings or additional incarceration as a result of this. So I'll just say, by way of perspective, and I grant it's not the same as an expungement, but again, just to the core of the policy, how much time one might do and just how severe the consequences might be. It doesn't seem strange to me. And I get that the mechanism here is a little, it's not what would happen if we actually had full control of the process, but I think it does put the question squarely as if this information is put before us, why wouldn't we want to consider it if someone's about to get, some additional penalty? And so having some mechanism for that, I'm certainly in favor of it. And my hope would be that the fact of this happening does trigger some sort of, at least informal, monitoring, collection from the PDs or whoever it might be, that they need to start talking to the courts about setting something more uniform up. And I say that with the backdrop of, I sort of agree with the last vote. We talked broadly about, sort of cordoning off work here, but this seems like it might be doable for me, at least.
Mr. Bob, give Mr. Hart, Bob first.
Well, thank you. I do not agree with the idea of treating these technical violations as if they didn't occur. These are orders of the court. You are ordered to do A, B, C, and D, and either you do or you don't. If you don't, I think the court should be made aware of the fact that that didn't occur. Defense counsel is standing right there at sentencing and can tell the court, Your Honor, this was a technical violation. This was not a new offense. This happens every single day. The court, I think, needs to be aware of the fact that the defendant did not comply with the order of court. There should be a point awarded for that fact. Why would we treat this differently from an individual who performed his probation, did perfectly fine? He gets a 0. Somebody who violates probation, I think, should get a 1. And defense counsel can certainly bring any mitigation to the court's attention that is appropriate. So I do not agree that there should be any change in the scoring of violations, whether technical or non-technical. Thank you.
So a few points. Similarly, just to address Mr. Harvey first, the prosecutor standing next to the defense attorney can say, this person violated his probation with technical violations. And that can be brought to the court's attention from the state's perspective just as easily as from the defense perspective. To me, having represented so many people who, for example, have a nonlinear recovery from drug addiction, who are hauled into court, to drug court, or are hauled into mental health court on so many occasions because they haven't followed through correctly with their treatment. They're found in violation, the technical violation, and they're pushed to recover. To me, that was the whole point of the JRA, and to address those sorts of violations with, financial investment in recovery and drug treatment and mental health treatment, but then to continue to treat those people the same way with respect to their violations of probation doesn't make a lot of sense to me. I'm not suggesting they should be treated like expungements. That to me is not what I think the proposal was. I think the proposal for now is the expungement rule in the guidelines was that if the defense attorney can show that a case could have been expunged, but the defendant never got around to doing it, that the offense, the prior conviction, should not be scored. That's all. That's all that rule was. It was put the burden on the defense attorney to show that a prior conviction could have been expunged and therefore not scored, but the defendant never did it. That was a fairness, a basic fairness and equity thing. Well, this is, to me, the same thing, a basic fairness and equity as it relates to the JRA, as it relates to technical versus non-technical violations. And I think that it's the right thing to do in light of the JRA, the policies that were presented and passed by the legislature, and that as far as how we go about doing it, we can talk about that in the next phase of the discussion. But I think that as a policy, the commission should pass a rule that technical violations do not score in violation of probation.
Want to wait?
The problem-solving courts are not subject to the JRA. We're outside of it. So I hear what you're saying, but that's one of the reasons why somebody may want to opt into a behavioral health clinic because then they are not subject to these technical violations. Because we do know that recovery and mental health court and drug court is not linear, but they stay with us a bit longer because we're working with them. So there's detriments and benefits, but they weigh that when they're directed. Would you like to come? And they say, oh no, I want to do this straight. So I'm just saying, you know, the 15 and 30 thing doesn't operate when you're working with that.
Montgomery County, they do it a little different. That was my experience, at least. They were declaring upfront technical versus non-technical.
I do want to respond because scoring the violation of probation is not an additional punishment. It provides information. Yes, you get a point, but you have violated your probation. It's not giving you, scoring the technical violations is not an additional punishment in any way, shape, or form. Also, I just lost my train of thought. You'll have to come back.
Judge Avery, we've had this back and forth so many times. In the trenches, it is.
Well,
Maybe not with the judges in your view, but in the trenches, it is a punishment.
Well, okay, except for the fact that the sentencing event is not just the sentencing score, right? The sentencing event also involves human beings, a defense attorney, a prosecutor, a judge, and there's so much more information that comes out. And honestly, it's like, I think I may have said this before, but all the angels that can dance on the head of a pin, we are not going to capture all of that in one score in this process of determining the sentencing commission, the sentencing score. So I think that this is another example of just parsing things too much so that you lose sight of the purpose.
I just wanted to speak to legislative intent again. And as Elliot Moon had mentioned, I remember long discussions drawing distinctions. Because, prior to JRA, there was violation of probation. We specifically, with intent, made a distinction between technical and non-technical violations. Hence what I think when we had our discussions, I said, I think it flies in the face of the legislature's intent not to treat these things differently when it was our discussions to say that they should be treated differently. And whether or not paragraph 2 is the way that we treat it differently, I don't know. But there should be some distinction or difference in how they're treated. And I think to do nothing and to keep it as it is not in keeping with the intentions of what we did in the General Assembly.
I'll jump in for a second. So I was also involved in JRA. I was on the conference committee, which finally hammered out the compromise that passed. I don't remember any conversation about the defendant being charged with another crime sometime later on, and then being convicted, and then in any way the technical violation or the real violation
coming into play with respect to sentencing at a subsequent occasion. We never discussed that. And I've got a question about the practicalities of this. So you have the initial crime, you have the conviction, you have the defendant sentenced to incarceration, goes into jail, comes out on probation, and then there's a violation of probation. And then 2 or 3 years later, there's another crime, a separate crime, trial, conviction, and there's about to be a sentence. And what this says is that at the time of the sentencing, the defendant must prove that the prior violation was technical. So it suggests to me that at the time of sentencing, we're going to have like a mini trial. I'm suspecting that the state's attorney is going to disagree that it was technical. So you're about to have the sentence, but you're now going to have a mini trial on one element of the sentencing guidelines. I don't think anybody contemplated that when the guidelines were adopted. I'm not sure it's a good idea. And if we start to get involved in mini trials about the sentencing guidelines, what other sentencing guidelines could also be the subject of little mini trials at the time of the subsequent sentencing? Is there a judge here who is involved in this, who could explain how that would work? How would you establish at the time of the subsequent sentencing whether or not a prior violation of parole was technical or not?
Ideally, the judge filled out the form.
Well,
Because that was a conversation, because that is the can I just tell you, that's why the form was made, so that the conversation and decision is made at the time of sentencing. So there's no doubt the argument takes place before the judge. Is this technical or non-technical, right? Because that's when you're going to have the clearest vision of it. Not when you're figuring out, oh my gosh, now we got in trouble, right? You're all standing there going, what is the deal? So the irony of all this is what the district court judges who do use the form are not subject to the Maryland sentencing guidelines. How ironic is that also? Not just suggesting.
What you just
where it should be being filled out properly, because that would be when you would have the better understanding. And that's when it's usually, oh, this is just a technical problem. Because I think that's what we all thought it was going to be. Or they just want this to be just technical because you didn't report. You're supposed to report within 24 hours or how many ever hours, depending on if it's a Friday and holidays and whatnot. And you didn't quite do it, or not that. But sometimes judges issue those violations of probation to bring the defendant in to just make sure, don't even start getting off track, because this could be a bad thing. But what used to happen is the judge would say, look, I'm not going to violate you. I'll dismiss the violation, but you make sure you have it all together. But now, if you don't count it as technical, you can't get to the, you see how sometimes things have absurd consequences. If you don't count it as a technical violation, you can't keep moving forward. If you have somebody who keeps coming back every 6 months and they're on 3 years or 5 year probation.
what you just described is the federal sentencing system, arguing ad infinitum over whether somebody should get a point or two for this or that, and actually having a lengthy sentencing hearing over guidelines points. Mr. Fincy can correct me if I'm wrong, but I think that happens quite frequently in the federal sentencing system.
Well, I think that is an extreme outlier statement. And Senator West, we have some matters already in the guidelines, and we're about to talk about another matter today where there are going to be some mini trials. And this is a matter involving whether a crime is a single criminal event. We need to correct it. There was a Supreme Court case, and there's going to have to be some findings by trial judge on what's a single criminal event. We already have it with respect to victim injury, where you could bring up something with respect to the nature of the victim's injury. They have it's a very mini trial because it's extremely short and it's not much of a hassle to deal with, but we're going to have those things. And I give you the example of the drug defendant, let's say a drug felony, has a drug problem, has a positive drug test, has a technical violation, a technical violation, and then completes probation successfully. 5 years later, he comes into a situation in the system again, And the question then is whether that single drug test, that single positive drug test should be scored as a violation of probation. So, I mean, you could make other examples that are much sort of worse than that, and I grant you that. But that's the kind of situation that I think that I'm trying to address with this proposed change.
The sentencing event they are mini trials, Senator. I have to say, I mean, that's what the sentencing event is for, is to parse these things out. My problem is having that parsing done on a form that, in my view, should be some very clear binaries. You know, it's either a click up, a click down, move on to the next one, get the score, and go to the sentencing event where the human beings provide the nuance. And that's just my viewpoint on this issue, is that, you know, whether there is the existence of a violation should be on the form, should be scored, move forward. To the extent that there are nuanced arguments to make, you know, if you have someone who has multiple violations because they're coping with a drug problem, you know, that is something that you need to address in court. It's not to say, well, it's either going to be, you know, it's not about the length of the sentence sometimes. It is also about the terms of probation or the ability of the person to be on probation and work. And so sometimes there are qualitative decisions that have to be made that should be based on the reality of the person's life and their criminogenic needs, as opposed to just based on a number.
So that leads kind of to my question, and that is, with zero, you have zero, and zero and zero and zero is still going to equal zero. So if there's one violation of technical, then another violation, it could happen, right? Another violation could be technical. So you still have zero. But if you don't have it at zero, and there's a violation that's technical and you get a 1, and then there's another violation that's technical, would that also be an additional, still be that same 1, even though it's a different violation? And I know we're kind of leading to the next question, but different violation, different time, it still gets a 1. So it never adds on. Okay, that helps. That helps, because that was a concern that I had. The other thing is, the other concern that I had was with respect to the defense being able to demonstrate that the violation was technical in nature. You know, I don't have as much of a problem with that as I did when I walked in the door. Because I, you know, talked to my friend over here, but I don't have as much of a problem with it. I didn't like it because it felt like it was just up to whether or not you had good lawyering or not. And I didn't want, you know, I don't like it when you know, a person's life is, you know, hinged on that. Hence the reason why we have, you know, the sentencing guidelines sometimes. But it just seems to me that something should be in place to reap the benefit that was intended. And it seems like technical and non-technical violations are distinguished for a purpose. I wasn't around when you know, I wasn't around to create the policy of JRA, but the fact that we have folks in the room who can give us that legislative intent, I think it's very helpful. And I, you know, maybe zero is not the answer, but it seems like the best answer we have for right now, in my opinion.
I just want to add just a couple thoughts on this, having heard everyone. So I always say we've had this issue come up in the past since we first started, that unlike the federal system, these are not mandatory guidelines, so that it's not as though the court is required to give a sentence within a range. We have to realize these are all about judicial discretion as we do this. And I view this as us talking about a prior record. This isn't like, so when we talk about the fact that, you know, we initially, the JRA, and actually testified in favor of that. I was in favor of that. I think when we get the technical violations in a probation, we do that. I think we ensure, frankly, my experience a lot of times has been there's many more violations before we even get to the incarceration. Because if it's things, as Rick says, it's about someone using or testing positive, we're typically trying to find another way to get them treatment. But it is a prior record. The JRA also changed a lot of criminal offenses that it's still part of their record, but we recognize those changes were made. So I think it's important to note that back when I was on the committee before, this is the same issue to me as it was with juvenile scoring. You might remember this. It was the issue of commitments, and you got it. Okay. It was the same issue. It was like, well, we're giving a 0 to people that perhaps had 10 technical violations, and we're giving a 0 to someone who was completely compliant with probation in the past. And to me, that doesn't seem fair for them to be scored the same way. That's one issue that I have with it. And to Judge Avery's point, I think as a judge, when you're looking at this, you're looking at it in terms of amenability to supervision. And whether it's a technical or non-technical, that's a factor. I will say, I just had this, not all technicals are created equal. We'll have a failure to report, or I have a child pornography case where the person is using someone else's iPad to view pornography. Well, I view those as different kind of technical violations, although it's technical violations still. It's still technical.
Yeah.
You could declare that not a technical.
Well, I could declare a
You
public.
could find that not to be technical.
Again, but that's true with any of them.
I know, that's true with any of them.
The
So
judge could find a public safety violation. My point is, it
that's
starts off
clearly a public safety.
in the technical category because it's not one of the listed. So there's a debate there. And generally, to Judge Avery's point, this is where everyone comes in, will argue. Rick will say, look, yeah, they violated before, but it's been drug related. Or the prosecutor may argue that it's something different. The other issue I have is not the forms that we get now that we can implement. But we're talking about a historical thing that you would have to try to go back and determine that. So that was just my thoughts on this. I think I appreciate the reason for looking at that, but I thought of the juvenile because that's kind of what we had then. It was like, how do you score those 0 when you're going to assign the person who's been there, has done great on probation, done everything they've ever been asked, and they're getting scored the same way. So I think and we're talking 1 point, no matter how many technicals they had, it's still only a 1 point, and it's 1 point that is going to move the discretionary guidelines for a judge to look at. So I think probably historically, since we look at guidelines as being reflective of what judges do, I think you would probably find that judges will generally consider someone's prior violation, regardless of what kind, in factoring in what to do in a brand new circuit court or at least guidelines eligible offense.
Mhm.
So this isn't redoing another violation. This is someone who then commits an entire new offense. So
But doesn't a judge have the discretion to give, to put 0? Or is that discretion there now? Or must they put 1 for a violation?
I would say the guidelines requires that there be a 1. The judge doesn't have to sentence within guidelines.
Right.
So even if there is a 1 and it's 3 months to a year, a judge could say, I'm not going to give any jail time. And I assume Rick would say, hey, look, they got a 1, but it was for this reason or that reason.
I guess what I'm saying is that if the judge has the discretion to say exactly that, on that form, would they put a 0 or would they put a 1, even though they say, I'm not going to give, I'm going.
Oh, it's still on there.
It's still a 1 on
It's
there.
still on there.
And be
Just like
if they
prior
went below the guideline, it would be a non-compliant sentence.
Right. It would
Correct.
just be a non-compliant.
Right.
Right.
Unless there's a sentencing alternative or something like that, which
Right.
in drug cases typically is one of the things that happens anyway. So it winds up being compliant, even though you're giving something below guidelines. Did you have, yeah. I didn't mean to steal your thunder.
No. That's, well, because I do actually want to pick on the other time this conversation,
Okay.
kind of conversation happened to sort of ground a precedent for, I guess, how this conversation is going to go. And let me just quickly throw out too, one of the facts that's sitting here bothering me is as I read this, I say on the flip side of what you're saying, we're going to treat a technical violation as if they were convicted of another crime. I mean, that's also unfair. So I kind of think that, you know, you have to choose the unfairness one way. Again, the intent when we set this ship a sail was we did not anticipate we would be having these kinds of conversations later. So I guess the thing, you know, stepping back though for a second, you know, I'm sitting here taking notes, and I'm sure Charles is. I pulled out my bill brainstorm list for next year. My JRA and specialty courts, points, and you know, parole violations. And then I ran through the thought process. I'm like, wait a second, we've seen this movie before, and I'm like, this must be exactly what happened to Kurt and Valerio. The two of those legislators must have been sitting here with the Sentencing Commission trying to win the argument on the juvenile offenses, lost the vote. You all came in and testified against it, and they said, no, that's not what we're trying to do. They passed the bill. And suddenly I was like, oh my gosh, we're about to do this again. So before we go down that road, I actually am just curious how we conceive of that process. You know, where's the boundary between what's legislative fodder for how the Sentencing Commission operates versus where does the legislative intent guide? What should we have done, you know, differently? And can we, before we do anything else, can we sort of avoid falling back into that same?
Well, you could create an expungement process for technical violations. I mean, if you wanted to do that, if that's really what you want, then, you know, propose a statute that says that, you know, for all future purposes, any technical violation will not be reported in any way as a violation of probation.
Or upon successful completion of probation, all prior technical.
Well, it doesn't matter because if you're doing a sentencing guidelines worksheet subsequent to the technical violation, then the person is likely violated again. So, I mean, again, keeping the big picture in mind here, people, is like we're talking about a subsequent criminal event.
Right.
So,
And I think that's the thing is, I think that's where there is an analogy to expungement, because really what you're saying is you shouldn't consider it in a new criminal offense. It shouldn't be considered at all. And that's obviously a policy decision that is a legislative decision. I think as a sentencing commission, it's hard for us to say, don't look behind the door, because that is a prior event. That's like a prior record. It would be us like not looking at prior offenses that haven't been expunged. You know, now we've got an argument that's made, but.
You know, at quarter points or half points. I mean, again, I'm looking for the distinction. That's all we're saying.
That's the question, Jim. Black and
but
white,
again,
right?
the angel's on the head of a pin. Like you cannot parse everything down to, you know, the metaphysical cellular level. You have to just have, I mean, we're talking about a form that is filled out by a variety of people. Some, you know, in some cases it's a law clerk, in some cases it's the prosecutor, in some cases the judges do it themselves. It should be a binary. It should be a, you know, I mean, I know we have drop down menus, but really how long do you want that drop down menu to be when what you really want is to get the information to the judge so the judge can consider everything, which is the judge's job, and make a discretionary, nuanced sentencing based on the information that is presented by the human beings in the room.
Anybody else want to weigh in? I know this is generate a lot of topics. Anybody else?
I would call the policy question first.
Okay, well, that's what we're going to do. We'll do the policy question. I don't vote.
Well, anyone could make a motion.
But I would say, so we need a motion and we'll need a second, and then we can
do roll call.
I'm sorry, can I just ask for a point of information here? I hate to belabor the point, but I am just, again, thinking back to the past scenario, the past precedent here where the lawmakers on this body disagreed with the vote. Yep, it sounds like we're about to take one of these. Disagreed with the vote, went back and legislated on that same topic. I just want to be on the same page here. It sounds to me like some folks are suggesting aspects of this are a matter for the legislature. Does that sound correct?
Well,
That if we later do revisit this topic, we're not going to have the Sentencing Commission in opposing us on the basis that we're out of our.
That's a tricky question. I mean, there was a lot more to that story with
I'm sure.
and the commission spent 4 meetings, multiple meetings debating the juvenile score. And what it really came down to was coming up with a more fair way to measure one's prior juvenile record. And the commission did a lot of work and got that. And then there were a certain number of commissioners that thought we should just abolish the juvenile record altogether. And there were very good reasons why the commission felt that that was not the right approach to go. And I think the Sentencing Commission is the right body to make determinations about what aspects of prior criminal records should be scored as part of the sentencing guidelines. So I think the pushback that you heard from the commission was like, we debated and had these arguments over multiple meetings and ultimately deliberated and had a vote and determined that the juvenile record should be scored as part of the sentencing guidelines.
And I think it actually, not to cut you off, but there was, I mean, the research had been done.
Correct.
There was like a year, I think, spent just
More than a
doing
year.
the
Yeah.
analysis. I mean, it was a really lengthy discussion. And so I think, and I'll just speak for myself, but I remember during that time, it was kind of split. I think one of the things about that is good with the commission, and many times I was not on the winning side, so to speak, but that we really were able to debate that out. And I think it was a different situation. I think if there's like JRA, there's a policy decision that the offenses were recategorized. I think the commission does that. I think we look at it as reflective. The only thing I will add is, I think one of the things we get the benefit of too is how judges are really going to use this. So I think whether you don't include that point or you do include that point, the reality is the judges are going to look at amenability to supervision. So I don't know that the one point really sways ultimately what's going to happen with that case, but that's just.
But that also goes to the really fundamental value of the guideline scoring system is that it's designed to as closely mirror the actual sentencing practices. Because going back to fundamentals, we are supposed to be primarily descriptive and not prescriptive. So we are not supposed to be telling judges what you should impose as a sentence. We are telling judges what is a customary framework for a reasonable sentence. And if a judge customarily is considering the juvenile record or the amenability to supervision and success on supervision, then we have to count it because it goes to the legitimacy of the guidelines. And that is what I keep coming back to, because if we undermine the legitimacy in the eyes of judges who use the guidelines, then the judges will ignore the guidelines. Because if you're telling judges, oh, don't consider that there's a juvenile record, don't consider this violation of probation or these violations of probation because they were just technical, then judges actually stop believing in the legitimacy of the guidelines. And that is a problem. That's an existential problem for the guidelines. So I know it seems like I'm harping on this, but I'm telling you, like, if you go back through the whole history of the sentencing guidelines, the legitimacy of these guidelines is really important to the existence of them. And so again, if you keep chopping it up and adding more and more responsibility, and it starts to become more what someone is telling you you should sentence someone to, then judges will ignore it. And really, there's no reason, there's no reason why they wouldn't, because, you really can impose a sentence that you think is right one way or the other. And the existence of the guidelines really does rein in some outliers in the sentencing world, okay, regionally, across race and other demographics.
Yeah, so I would just add to that point real quickly on the juvenile, and that was part of, I think, there and why on some issues, the sentencing guidelines committee, in my experience here, has not weighed in, and then on some things it has. And I think to Judge Avery's point, that's exactly the point, that I think when it threatens, I guess, the legitimacy, or as a good example of the word, but because with juvenile court, it was the same thing. It was like, well, you're not going to treat someone who's ever had a juvenile offense in their life and for the first time did something as an adult the same way as someone who's 19 and has had, a history of you. Like, a judge is going to see those two different. And if we deny the reality of that, then at some point we are not really serving the better purpose of harmony in sentences, regardless of where you are in the state. That was the concern. And I think it's similar here. I mean, I do think that judges are going to look at it. I mean, we look at how you did on pretrial supervision. I have people on pretrial all the time, and if they've done a great job, it's like, hey, you've done a really good job on supervision, let's keep you going. And if they haven't, well, that's a factor I'm going to consider in deciding whether or not I give more supervision. And I think it's similar here. But that's just my final 2 cents. All right. Well, I guess.
I'm happy to make a proposal. I don't know how to call the policy.
I guess the policy
question.
issue would be number one, whether or not the Sentencing Commission should explore the procedural mechanism in order to not consider, or how to not consider technical violations.
I would say we call the policy questions to say whether the sentencing commission should continue to
Okay.
count non-technical violations of probation to score a point.
Okay.
Then we can deal, we don't have to necessarily even deal with
Tonight.
bigger technical issue, not technical, but technological issue. That could be done in stages even. It could be the defense.
No, that's fair. And that might actually have to be explored more.
Eventually, there's gonna be data in the system. It'll be much easier.
Okay.
All right. Anyway, I would call that first. I would make a
Could I just clean that up a little bit?
Sure, definitely.
And it depends what the motion, which way you want to go with the motion, but I think it should be, and you wouldn't word it with should, but I'm going to start with should, but it would be the prior adult, part D of the prior adult record should or should not make a distinction between technical violations when scoring the prior criminal
That's
record.
right. Wording.
Should or should not, depending on what the motion
It's gotta
is.
be a declarative, so if you say should there should be change in the current.
Right now, we don't have to, if there's no change, we don't have to have anything.
Right, exactly. So I think if you call the question as should there be a change,
Okay. Okay, yeah.
or
that's
should you
fine.
remain the same? Let's say, should it remain the same, where I'm trying to sort it out, so it's
Okay.
a simple declarative. Should the existing policy of scoring violations of probation with a point, regardless of whether it's technical or not, should that policy remain the same? Should the current policy remain the same?
But how would you vote on that? We'd have to declare it some way. We have to
Is it
say the
different from
policy
what you
should
have
be.
here? Or is it whether the sentencing commission should decide to make no change to the instructions for scoring part D of the offender score? Is that
Yeah,
the question?
the issue is whether there should be no change or there should be change.
All right.
Right.
But you got to do it in 2 parts, right?
Well, I think the motion has to be either one way or the other,
Okay,
is what I'm
so-
saying. You have to be able to vote yes or
Right.
no.
So
You
the
have to-
motion, we
Well,
can start with.
I move that the commission should make no change in the current scoring violations of probation, regardless of whether the violation is technical or non-technical. That's my motion.
Okay, I think that's a clear,
All
right?
right, is there a
So
second?
if there,
Okay,
All right, Judge Avery seconds. Is there any
So wait a
further
minute,
discussion?
if the vote is no, there should be no change. So the vote is no, we have a double negative.
Right, the affirmative.
You're voting in the
answering
affirmative.
yes.
I just want to be
means-
clear what a vote yes, does a vote no mean that there will be a change?
Yes.
correct.
Okay, just be clear about that. I mean, just-
Okay,
Yes.
So yes means we
No
leave it the
change.
same,
Yes.
no means we make a change.
okay. So we're gonna do a roll call on this because I think it's gonna be, sorry, just take a minute, but if we could go around. I'm doing this in mostly alphabetical order. My last name, Judge Avery,
I'm voting for the motion.
yes. Delegate Bartlett,
Yes.
Mr. Zarimba,
No.
Mr. Fincy,
No.
Mr. Davis on behalf of the Attorney General's office,
Abstain.
Secretary Green, sorry, Secretary Green, can you unmute?
No.
No, okay. Melinda Grenier,
Yes.
yes. Mr. Harvey,
Yes,
yes. Brian Johnson,
No.
no. Judge Lewis,
Yes.
Alethea Miller,
Yes.
Delegate Moon,
Yes. Oh, excuse me. I am voting against.
You're voting no.
Yeah.
no. Okay, Judge Salmon,
Yes.
thank you. Kyle Scherer,
Yes.
yes. Lisa Spicknell, yes.
Yep.
Senator Sidnor,
No.
no. And Senator West,
Yes.
yes. The yes votes are the majority by 10-6. So the vote is in favor for no change to Part D of the offender score.
That was a
That
little complicated.
was a little complicated.
We gotta work on motion. Our motion game is not as strong as the committee.
We'll work on that.
And I think last time I testified for the judiciary. So
Okay.
maybe we all have our constituencies.
Okay, should we, for the sake of time, move ahead? The last item on the agenda, we're going to get a presentation from afar. No, just that Stacy and Najeka will introduce this topic for us. So this is agenda item 5C, the proposed clarification for the definition of a single criminal event. Stacy, I'll turn it over to you.
And before Stacy begins, can I just say that this was a consensus from the guidelines
For the
of,
last item,
for three, for
5C.
the proposed clarification. Wasn't that a unanimous?
Correct, yes.
So maybe we could cut through some of the description and maybe do a summary,
Sure.
Yes, that.
because we all agreed on this.
Right. Yeah, we could do that. So I could try, maybe I could, Stacy, I'll just take a shot at that and just cutting it. This is an issue that has come up before. It's an important issue relative to the guidelines because there's a distinction made. If it's a multiple criminal event case, then the guidelines will get for each single criminal event will get stacked on top of each other. So the instructions in the manual don't provide an over amount of information about making the distinction about what a single criminal event was. The staff, I can't remember exactly how it came about, stumbled across sort of this recent Supreme Court case, the Wooden case that we referenced, and I did send to you. And that case does provide, it was an interesting case. It involved kind of a situation, and the Supreme Court got into this about a case that involved 10 burglaries and what constituted a single criminal occasion is the word they use. But that really is similar to what we're calling a single criminal event. In light of the ruling in that case by the Supreme Court and drawing on the guidance of that case, the staff offered to the subcommittee, and the subcommittee unanimously agreed with our recommendation to present clarifying information in our definition of a single event. And it would read, and this is noted on page 3 of your memorandum, that in determining whether multiple crimes are committed in the course of the same transaction, the person filling out the worksheet shall consider 1, whether the crimes are committed close in time, in an uninterrupted course of conduct, 2, whether the crimes occur in the same location, and 3, whether the crimes are similar in nature or intertwined. For example, whether they share a common scheme or purpose. I want to note that this language would not alter the current guidelines rules in any way. Rather, it is provided to help provide what we think is more clarity for the people that are scoring the sentencing guidelines. So the subcommittee agreed that borrowing this language from the Wooden case would be helpful. So that is the recommendation of the subcommittee to adopt that language.
Shall I move?
Any motion?
Move.
All right, motion to adopt that. Any second? Second. Any further discussion? All those in favor say aye.
Aye.
Anyone opposed? All right, no opposition, that carries.
Okay, great.
And Stacy, thank you for your work.
Thank you.
Sorry, I didn't mean to steal your
We got
thunder.
No, not at all.
We used up our reservoir.
Exactly.
No more argument now. All right, the executive director.
Okay, more talking from me, but I'll be pretty brief here. I have a few items to discuss and one announcement. First, just to kind of give an update, we have upcoming updates to the sentencing guidelines. At our May meeting, the commission voted to adopt changes to the scoring for the juvenile delinquency score and to revise the offense classification for first-degree arson. The juvenile delinquency component, that was just a minor aspect where we basically said that the instructions will now explicitly clarify that adjudications that are based on acts that are no longer crimes shall not be included. So we already had made that distinction for the adult criminal record. So we're doing the same thing for the juvenile record. And so that will go into effect on October 1st. And the same thing we had, as you may remember, we had reclassified arson first degree from a property offense to a person offense. And those updates were promulgated through the CROMAR review process, and they will be adopted effective October 1. The second item I wanted to report on is just to give you an update on sentencing guidelines trainings and feedback meetings. Since our last meeting in July, the staff has been doing a few trainings. We completed one webinar training. Also, Catherine Pembroke, who is our training coordinator, and if you call the Sentencing Commission, she's the one that's typically answering the phone and providing all the great advice and input that she does. She provided a judicial training webinar on July 22nd. And this training webinar is just kind of a general overview regarding the sentencing guidelines. And she also talked about recent updates like the changes to the drug matrix and property matrix that were adopted on July 1st, et cetera. And this is something that is available in the judicial archives. I'm also pleased to share that the Sentencing Commission staff has put together 3 upcoming webinars in September and October. On September 6th, which already passed, sorry, we provided an updated orientation and training for judicial law clerks and other judicial staff. Actually, that's upcoming, right?
That's on Friday.
That's on Friday, sorry. Last week, Catherine went out to Kent County and did a presentation specifically for their jurisdiction. That involved the state's attorney's office and also judicial staff. But this Friday, we have I think I just have their own date in there, one for judicial law clerks and judicial staff. And then on the 30th, we are offering a MAGS 101 webinar for prosecutors and parole and probation agents who initiate the sentencing guidelines. On October 6th, we'll be offering a very similar webinar and orientation for public defenders and private criminal defense attorneys. All information about those is available on our website. So if you want to direct any individuals for participating in that, just that you can find the information on our website. The third item I wanted to report is about new staff. I reported at our last meeting that we were fortunate to add 1 full-time staff member to our staff. We haven't done so yet. We're in the process of hiring. So this resulted from the adoption of Senate Bill 763 and some of the actions that the legislature has required of the Sentencing Commission, primarily a new report that we will have to do on crimes of violence and putting a data dashboard together that will be on our website. So we are currently accepting applications for that position, and we have We originally had a best consideration date at the end of August, and we've extended that to the end of September. We have not received a lot of applicants to this point. You probably all recently saw the email that we circulated, so we're hoping to generate further interest. If you know anyone that you think may be a good candidate to this position, tell them great things about us and encourage them to apply. Again, you have that email that we sent, but we also, you can obviously just reach out to me, and the application is submitted through the University of Maryland application site. Finally, I wanted to talk about the public comments hearing. So on December 6th of this year, we will hold our annual public comments hearing. As you all know, that's something that we are statutorily required to do, to have one of those every year. So the way we've format for that is we will have a public comments first and then a traditional business meeting after that. We will distribute a hearing invitation about that public comments hearing to criminal justice stakeholders throughout the state. So that's one way we will advertise about it. Our intention is for that meeting to be in person. It will be held here. I think we're going to be in this same exact room. We are planning also to have the ability to, since this seems to have worked relatively well tonight, that we could live stream the hearing and potentially allow individuals that want to provide testimony to do so virtually through Zoom. And I think this was a good test run to see that should work relatively well. So I just kind of wanted to give you that format, that is the plan for December. The last part I really wanted to do is just to ask for your help. I wanted to ask that you think about people that may be good resources or good individuals to testify to the Sentencing Commission. If there's anyone in your your agency or whatever groups you may work with that you think are thoughtful speakers that can, speak to the Sentencing Commission about the type of work we are doing, I encourage you to reach out to those individuals. I will send a hearing invitation about that in the next month, so you can just forward that on to anyone that you think may be a good speaker. The last thing I wanted to speak about, I know that was just the announcement that I had, and he is in class tonight, so he wasn't able to join us, but I'm happy to report that Mark Mills is remaining with us for a second year as our policy analyst. He is he's our graduate research assistant. He works with us 20 hours per week. He's a doctoral student in the Department of Criminology and Criminal Justice at the University of Maryland. He also has a law degree and was a prosecutor in his past career. So he is a tremendous resource for us to have on our staff. So we were very pleased and lucky to have him back with us for a second year. So that will conclude my report. Happy to address any questions at this time or move on.
Any questions? No? All right. Any old business? No. Any new business? Announcements? Anything exciting? No?
If I may, Mr. Chair?
Yes.
Secretary Green, thank you. I just wanted, can you hear me okay?
Yes.
Very, very good. Thank you. Struggling to hear a little bit here this evening. The department appreciates the conversation earlier around Division of Parole and Probation data. And to that end, I think many in this room may know we have been actively and for a period of time working on a dashboard around some of the very data that has been discussed here tonight. And we're in the final stages of having that dashboard again finalized and hopefully ready to go in the coming weeks, next month at the latest. But it will get into some of our field work, technical revocations in the field, and I think some other interesting information that was perhaps discussed here tonight.
That sounds interesting. Is it a possibility, Secretary, to present? I don't know if the committee would be interested, but once you've launched that, it might be a good presentation to kind of see what, especially because we get these inquiries about all this other data, to maybe have a presentation to the commission about what it offers and what information is there?
Certainly. We've taken a very active role over the last year of really last 2 years, rolling out a number of dashboards. You can find those on our website, to include the recidivism report that was recently completed, all of our JCRs, all of our data, in the spirit of making sure everything we have is available. The DOC dashboard is a very robust dashboard, and with recent and I think continuing interest and appropriate interest in the work of the Division of Parole and Probation, what we do in the field and how our flow of work occurs. We're taking all that data that we can find and mine and putting it into yet another, I think, very robust dashboard. So when that work is absolutely finalized and completed by our Director of Data Development, Ms. Carino, I know Dr. Soleil is familiar with her work. We will be happy to present that.
Oh, great.
I think it's very interesting.
Sounds like it. Very well.
Thank you, Secretary Green.
All right, anything else? With that, again, thank you both. I hope that,
We have many more discussions like you just did.
all right, see everyone in December.